Thank you, Chairman and members of committee. I am proud to sponsor what we call Trey's law today. That is LC 492538-EC. I'm carrying this on behalf of the governor, the First Lady, and the Grace Commission. Been very grateful that I have been able to carry a lot of the First Lady and Grace Commission's human trafficking bills since I've been in the House, and this is one more piece of legislation that is going to help victims in our state. What essentially this bill does is it's going to prohibit the use of non-disclosure agreements, or NDAs, in civil settlements involving child sexual abuse, and human trafficking. These NDAs silence survivors of sexual abuse in civil settlement agreements, and it forces victims to choose between compensation and their voice. The purpose of this law is to ensure that survivors can speak openly about the abuse they suffered, help expose abusers and negligent institutions, and prevent harmful secrecy in future cases. Essentially, we've been seeing victims entering into civil settlement agreements, and they're forced to sign NDA agreements, and so later on they're not able to speak about the abuse in getting help, mental health help. They're not able to talk about their experience. So essentially what this bill does is it frees survivors to share their stories, allows for mental health support, and uncover patterns of institutional silence and negligence. It essentially prioritizes survivor voice and public safety over secrecy. This law is named after Trey Carlock, who was a Texas resident who also lived in Atlanta for about 4 years growing up. He was sexually abused as a child at a summer camp where Georgia is one of the camp's top markets. In his civil lawsuit, Trey was required to sign an NDA that prevented him from sharing his experience. And this legal silence contributed to a lifelong trauma, and he eventually took his life in 2019. I am joined here by Trey's sister, Elizabeth, today, who has been an advocate for this bill around the country, and we will be the 5th state to pass this law if it moves forward. So we will be one of the lead states to enact this law as well. If I may, Chairman, before I take questions, may I have Elizabeth make a quick statement?
Yeah, that mic is hot, so go ahead.
Thank you so much.
Good afternoon, Chair Gunter and committee. My name is Elizabeth Phillips, and I'm in town here from Dallas, Texas, although I lived in Atlanta during my middle school years and have so many fond memories of growing up in Georgia. But today I'm going to share about some darkness that remains in this state, and I thank you for your support as I try to get through this. It's emotional, but it's very important. I'm here to speak on behalf of my late brother, Trey Carlock, the namesake of this bill. I adamantly support HB 1187 named in his honor. First, I want to thank bill author Representative Hong, the additional sponsors on this bill, and especially Governor and First Lady Kemp for making the protection of children a priority in this state. Georgia is now part of a national movement, joining states like Tennessee, Oklahoma, Kansas, and Missouri that say enough is enough. The silence of childhood abuse survivors in state civil courts is no longer for sale or up for negotiation. My late brother Trey was groomed and sexually and spiritually abused from the age of 7 to 17 by a serial sex offender named Pete Newman, a camp director at Kanakuk Ministries based in Missouri, but with programs around the country and world. Atlanta, especially, is one of Camp Kanakuk's largest markets. While Trey eventually saw his perpetrator sentenced to 3 life terms in Missouri in 2010, Trey was silenced in a civil settlement with Kanakuk that included a restrictive NDA when he sought to hold others involved accountable. Due to this NDA lawfully hushing Trey and so many other John Does from talking about what happened to him and everyone involved in the institutional cover-up, there was never justice or true accountability. No one was fired or terminated as a result of this abuse, and the same leadership is in place today. His NDA, which I was finally able to see for the first time in September 2025 after we passed Trey's Law in Texas, was extremely intimidating and made him scared to share about his trauma, even in clinical and therapeutic settings. Because of Kanakuk's intimidating legal tactics and the NDA attached to settlement dollars Trey needed for healing, I have learned more about my brother's abuse and his death than I knew in his life. He died by suicide in 2019 because he wasn't allowed to have a voice, and as anyone in psychology knows, that inhibits healing. A few days before he died by suicide, he told a therapist, "They will always control me and I'll never be free." He was 28 years old. My brother played NYO baseball in Chastain Park. He was a soloist for the Atlanta Boys Choir. He was beloved and talented and brilliant and had such a bright future ahead of him. Instead, his life was ruined by Kanakuk's institutional abuse on top of the child sexual abuse that led to his death of despair. We now know many other suicides associated with Kanakuk abuse, so this is a matter of life and death. This is an urgent matter of public safety and concern. I often say Trey had 3 abusers. First, the direct perpetrator. Secondly, the institution who knew of Newman's misconduct and promoted him anyways. And lastly, the system that failed him. The short statute of limitations on child sexual abuse and trafficking cases forced Trey to file civil litigation before he was ready, allowing NDAs and also barring victims from the courts due to short SOLs makes for a hopeless situation. But today, this committee hearing is bringing hope. This room is packed because survivors are finally able to have a venue to be heard in Georgia. Georgia is making a loud and clear statement that this state stands with survivors and wants to hold bad actors accountable. Without Trey's Law, civil settlements for child sexual abuse, sexual assault, and trafficking cases can include an NDA as a matter of standard practice in personal injury law. This is widespread, and we must give victims their voices back when they've already endured the unimaginable. With your help and other legislators' support, Georgia can make a strong statement to survivors that they matter more than a liable institution's reputation, and that misusing NDAs, initially created to protect trade secrets, not trauma secrets, are no longer acceptable in the great state of Georgia. Since Trey's Law passed in Texas and Missouri, by the way, unanimously and with full bipartisan support, the floodgates have opened. We launched the hashtag #TruthSetFree, and I have heard from countless survivors of sexual abuse across the country and world who have been lawfully hushed in civil court. Georgia was the first state where a governor has reached out to me and said this is a priority for him and the First Lady. I cried after I got that call because I finally felt momentum. I felt that lawmakers care and they want to hear survivors' stories and protect victims' voices by eradicating the misuse of NDAs in these horrific situations. I'm with you, Georgia, and I stand with the many survivors who would like to testify today. Let's break the cycle of shame-induced silence that predators rely on. Let's choose to act upon victims' cries for justice and freedom of speech so that they can have the freedom to heal. House Bill 1187 ensures that any clause or agreement intended to conceal the details of childhood sexual abuse is void and unenforceable as a matter of public policy. I'll end with this. There's a quote that says, "Shame dies when stories are told in safe places." By passing Trey's Law in Georgia, you are transforming the legal landscape of this state into a safe place for survivors to heal, for darkness to come to light, and for Trey's life and legacy to matter. Let's set truth free. Thank you, and I'm willing to take any questions.
Okay. Any questions by the committee?
Mr. Chairman, I have one, although it's for the author.
Chairman Leverett.
I think this is clear, but just for those attending, the effect of this would be prospective, correct? It's not retroactively nullifying previous NDAs, or is that the intention?
I know that has come up, and I think that's still in discussion at this moment. So Also, while we're talking about that, I think we did pick up on one more thing is on line 19, when we refer to code section 9-3-33.1 regarding childhood sexual abuse. There's two definitions in those two sections, and so we're going to go ahead and do a sub to refer to both of those sections to make sure that both of the definition for child sexual abuse is included in the bill.
All right. Representative Holcomb.
Thank you, Mr. Chairman. First, I'm very sorry for your loss. Second, I think to Chairman Leverett's point is we can't abridge anything in contract that is retroactive. That's not operable. But I do have a couple of questions. I'm very, very supportive of what you're trying to do. And listening to what you said, it sounds like your main priority is to ensure that there is no non-disclosure provision that would prohibit speaking about the underlying conduct. I have a slight concern about the breadth of the term concealing the details, because I could see somebody arguing that just the settlement payment itself is trying to conceal the details, and so I don't know if anybody else on the committee sort of shares that, because I want to make sure this is as tight as possible to where you can't have anyone try to circumvent it. Substantively, in terms of questions, would be, can you explain to me the last two lines, the accept clause of the accept that identifying information of a victim of childhood sexual abuse shall be deemed and maintained as confidential? Is that for the bad actor, that they have to keep it confidential? Like, how is that in practice play out?
So a few things. On the first portion, Representative, are you saying we should piecemeal what can be null and void in an NDA? Is that what you were referring to? As far as like, should the settlement amount or
I'm
are
almost
you
wondering-
piecemealing it?
Sorry to talk over you. I'm almost wondering if it would be clear to just say something along the lines of any non-disclosure provision contained in one of these types of settlements is not operative or void, and instead of using a broader phrase of concealing the details, because you just wouldn't want somebody to use a different part of the settlement agreement to, try to get around it, unless we want everything to be open, which I'm fine with that too.
That was the purpose, is to have everything
So
open.
even the amount?
Other than, correct,
Okay.
other than the information of a victim of the abuse.
Okay. Okay. I think that makes sense. Okay. And then can you help me with that, or did you already answer what the
Other than
second
the
part?
information of the victim of this abuse. That's why there's an exception.
Okay.
So it shall be null and void, shall be void and unenforceable, except that identifying information of the victim is going to be confidential.
Okay. I think I understand. All right, and then I'll ask this just in terms of with other states or otherwise. Like, again, coming from the viewpoint of being fully supportive of what you're trying to do, is there any concern whatsoever about this potentially being a chilling effect of keeping people from entering into settlements?
May I respond to that? Sure. We actually have empirical and anecdotal data on that issue, which is in the packets provided to the committee. There's been a study, especially on the enactment of a similar law in California back in 2016, and that shows that it does not have a chilling effect. It does not affect settlement values. And what we did pass in Texas was retroactive, by the way, because we said that any existing NDAs must have a special court order to remain in effect. So that got around the retroactivity constraint, which is in the Bill of Rights in the state of Texas. So I just wanted to point that out as well, since you brought it up as a concern to members here. And we have suggested some bill language that would also address the question you had about settlement values being protected. Our goal is to ensure that the ball is in the victim's court as to what information they want shared about their worst abuse. That is the North Star. And we're willing to work with the legislature on tweaking the language, and the bill sponsor has expressed that as well.
I think I got it, and if so, let me try to reflect back what I think that I heard, which is that this effectively would authorize the victim to release whatever he or she wanted to whatever extent and scope, and then at the same token, that individual's name would be concealed so that release could be done by some other party and not by the victim himself or herself, so that anonymity could be retained. But that whoever the bad actor was would be known to the public that they were in fact a bad actor. Is that correct?
Correct.
I got it.
And that's how we keep the from passing the trash. That's how we warn the public about who the bad actors are and which institutions and other parties are liable for said abuse.
Okay, thank you.
Thank you.
Vice
the-
Chair.
And if I can also, the way that this bill is written, it is effective upon the governor's signature, so it will not be retroactive.
Okay, all right. Vice Chair Reeves.
Thank you, Chairman Gunner. Every year, the governor and First Lady have been in office. They've moved the needle in a good direction on this, and I appreciate you and them bringing this bill. Friday night in our home county, Gwinnett County Street Grace got another award for doing good work in this area. Our majority leader got a public service award, but Street Grace got it specifically for this. Last year, Attorney Jeff Shaw spent some time at the Capitol. He's with Freedom Collective. They are working, in Georgia and around the country on, things like this of having recourse in the civil arena. Some people, jail time doesn't dissuade them. You got to hit them in the pocketbook too. So really appreciate y'all doing this. The claims are brought in the name of Jane Doe or John Doe in court. So this protects them in their settlement agreement just like they are protected in court, the victims. But the perpetrators don't get that benefit. So really appreciate you bringing this. And this is just one more message to, sex offenders and people preying on women and children. Stay out of Georgia. We got the Super Bowl coming here in a couple of years and the World Cup and all that. This kind of stuff's not tolerated here.
Thank you.
Representative Evans.
Thank you, Mr. Chairman. Thank you so much for the bill, and thank you for sharing your story of your brother. My kids play at NYO baseball, so that hits a lot of us at the table really close, and thank you for your bravery. I understand this is written not to be retroactive, and I understand the contracts clause, but given what you said about what happened in Texas, is that a possibility here for us to write something? I guess this is more for Representative Hong. Like, can we write something that says they won't, going forward, only if they are ratified by a court could they remain? Because I want us to go as far as we absolutely can, but it seems like that would be a great additional step if we could possibly do it. I feel like there would be support around the table.
So just as Elizabeth had testified in Texas, I think their constitution allowed it. Our Georgia
No.
is that what he?
It's very similar to Georgia's constitution, but
Okay.
the loophole was that to maintain and enforce an existing NDA, you would have to receive a special court order, which allows that remedy that gets around the constitutional conflict in Texas, which is much actually stricter than Georgia's constitution. And we've proposed it as a possibility. This has also been filed in Alabama, Oklahoma, Kansas. Senator Cruz and Gillibrand are about to propose it federally as retroactive. So it's something that we hope to continue discussions around as advocates.
And certainly we can discuss that to our knowledge. It can't be because our Georgia Constitution prohibits retroactive laws that impair contractual rights. So there's a section in our Georgia Constitution that prohibits that. So
Right. No, I understand. I mean, that's in the
I guess
federal
we'll look at
constitution.
that.
So I just think if Texas was able to figure it out, it might be that I know we all as lawyers immediately think contracts clause. But I just want us to, if Texas figured out a way to do it, I'm thinking that maybe we could. It would be at least worth a look. And I take Representative Reeves's point that, yes, when you go to the point of having a civil lawsuit, yes, that defendant's name is not John Doe. But so many of these cases settle before there's ever a lawsuit, and we all know that. And those people are monsters. And they don't deserve to hide behind a cloak. And I think if there's any way that we can figure out to bring those names out, we should try. Because I get it. I get the contracts clause. And I don't want us to do anything that would put the overall law in jeopardy. But it just seems like there may be a way, and it seems like we should try instead of just assuming that we can't.
Of course, we'll continue that conversation. Thank you, Representative.
Vice Chair Reeves?
And I don't think that sex offender perpetrators have the benefit of the contracts clause for criminal behavior of molesting children. I don't think they can claim under that, like, an insurance company on a contract matter or something like that. So I think keep pushing that, because I think you can make this retroactive for that criminal behavior of preying upon children.
Yeah. Anybody else? All right. Ladies and gentlemen, we have 10 persons that want to come up and speak. Everyone is in support of the bill, so I get that. If you would please, our time is limited here. Actually, we should be ending about now, but if you could just give us a few minutes and highlights and try not to repeat each other, that'd be great. I'm not going to put time limits on you. Just be mindful of it. All right? Hale Swinson? Or Haley Swinson? I'm sorry, is it Haley? Okay. Sorry about that misreading.
It's okay. Thanks for letting me be here. Hello, committee, chairman. My name is Haley Swinson. I'm here today in strong support of Trey's law. There's a quote that stayed with me throughout my healing journey. Justice is the final stage of healing. But justice only happens when leaders, institutions are willing to name the truth and willing to take responsibility for it. For me, this issue, it hits really hard. While Trey's Law was born out of the devastating abuse scandal at Kanakuk Ministries, a tragedy that led to lifelong harm for many and to ultimate suicide for Trey and others, this issue is not isolated just to Missouri. As Elizabeth was sharing, even for Georgia, this issue is not isolated just to one state or one institution. I'm a survivor of sexual abuse here in Georgia at a university. In my case, leaders use power, authority, fear, grooming, manipulation, and spiritual language to control and exploit. Abuse like this does not rely on physical force. It relies on silence, a power imbalance, and the fear of speaking out. When abuse happens, the harm does not end with the act itself. Survivors are not believed. We are silenced. We are left confused and ashamed, blaming ourselves for what was done to us. For me, the aftermath included years of PTSD, disassociation, medical trauma, seizures, and a long road of counseling and spiritual unlearning just to survive. The damage is compounded when institutions prioritize protecting their reputation over protecting people. As Brene Brown said, when an institution values power and money and image over human dignity, shame becomes systemic. Accountability disappears, control and fear become management tools, and there is always a trail of devastation. I was never personally forced to sign a non-disclosure agreement. But there were others who tried to stand up for me that were made to sign NDAs. Passing Trey's law would help survivors like me in the state of Georgia move forward without fear of being threatened, silenced, or re-traumatized just by telling the truth. It's been said, not everything that is faced can be changed, but nothing can change until it's faced. So today, you've been faced with the truth of what happened to Trey, what happened to someone in Georgia at a university here. And I urge you as elected officials to use the authority entrusted to you to advance and pass this legislation that protects Georgia's survivors and holds abusers accountable. To any survivor that may also be in the room or listening, you're not alone. We are standing with you, and the light shines in the darkness. The darkness has not overcome it. Thank you for your time.
Okay, thank you. Afton Phillips.
Chairman and members of the committee, thank you for the opportunity to testify. My name is Afton Phillips, and I'm an advocate for survivors of clergy sexual abuse through a grassroots online platform that amplifies survivor stories and documents systemic abuse of power in religious institutions. I worked for 12 years at a Christian nonprofit called Orange in Atlanta, Georgia. I gave my life to its mission. At its height, the organization served over 10,000 churches internationally, impacting millions of kids and teenagers. Almost 2 years ago, our founder and CEO was exposed as a groomer and sexual abuser of multiple women within its ministries. This was the catalyst that launched my team's advocacy work. Through our online movement, we've gathered experiences from many other women who shared similar experiences, women who were groomed and abused, some as minors, in a church setting. This problem isn't rare. My experience has made clear that abuse occurs far more frequently than people want to believe, in places that should be the safest, by leaders who are trusted, and against those who are the most vulnerable. My experience has also taught me that when abuse comes to light, the fight for justice is far from over. When I learned what was happening in the organization I worked for, I expected and wholeheartedly believed the board and other leaders in power would act justly. Instead, the leaders I trusted were silent, or minimized the harm, or blamed victims, or actively covered up the harm done for the sake of the abuser's reputation. I'm here today because something has to change. Survivors should not be silenced. They should be supported by organizational leadership and amplified by legislation that exists to protect and defend them. The justice system should not be a place where abusers can hide and perpetrate further harm. Too often, abusers have money, power, and influence, and in many states the law, to protect their image and silence their accusers. My hope is that Trey's law would begin to correct this imbalance by ensuring that the legal system serves survivors rather than enabling further harm. Thank you for your consideration.
Thank you. Chuck Willis.
Chairman and members of the committee, my name is Chuck Wills, and I'm from Atlanta, Georgia. I'm here in support of the legislation to bring Trey's law to our state. I attended Kanakuk from 2002 to 2015 and worked there for a summer. I also served in student ministry for North Point Ministries for over a decade. I'm here today because I care deeply about the safety of young people in ministry environments, and I'm close to this issue. Pete Newman brought me to faith. Joe White baptized me. However, Kanakuk's damage has ruined the lives of my friends and family. I have had friends directly affected by non-disclosure agreements related to the abuse they've experienced at Kanakuk. I've seen firsthand how these agreements can silence survivors and prevent families from knowing the full truth. Here's what I know. When NDAs are used to conceal the details of childhood sexual abuse, it does not just impact one case. It can prevent patterns from being recognized. It can prevent informed decision-making, and most urgently, it can allow harm to continue in the shadows. This bill draws a clear and responsible line. It protects the confidentiality of victims' identities, but it prohibits agreements whose purpose or effect is to conceal the details of childhood sexual abuse. As someone who has spent much of my adult life in these ministry environments, I believe this legislation strengthens communities and families by prioritizing truth and accountability over reputation. Survivors deserve privacy. Institutions do not deserve secrecy. Transparency protects children. I respectfully ask for you to support this bill, and thank you for your time.
Thank you. Christopher Epling.
Good afternoon. My name is Dr. Christopher Epling. I'd like to thank the chairman and members of the committee for your consideration of HB 1187. I live a little north of here in Alto, House District 27. I'd like to take a moment of your time to speak in favor of HB 1187. I'm an ordained Baptist minister and I work in Christian higher education. While I'm not a sexual abuse survivor, I have personal firsthand experience with being given a choice between signing an NDA and receiving a severance package, or not signing and being fired outright with zero severance. The reason for my termination, I believe, was to cover up what would come to be known as an alleged case of sexual abuse by an administrator with a student. That student would later become an employee of the university. I believe the reason I lost my job was for starting an investigation into this case and then attempting to get the president of the institution to perform a thorough investigation of the events in question. I was not allowed to continue any investigation into these matters. There may be appropriate reasons for certain organizations to use NDAs, such as protecting proprietary technology, techniques, or data from competitors. There may be some places where even faith-based institutions could be served by issuing an NDA, such as protecting salary information or giving records. The idea, however, that a faith-based organization, or any organization for that matter, would use an NDA to keep a victim or a whistleblower quiet, that idea is unconscionable. In John 14:6, Jesus says, "I am the way and the truth and the life. No one comes to the Father but through me." Now, I'm not here to debate the theology of this verse, but I feel that this verse points out a truth that bears on our discussion today. If someone in a position of power requires a person to suppress the truth, but through the means of any document, it seems to me that they are acting in a way that's antithetical to the life, character, and teachings of Jesus Christ. I wish I could say this only happens in faraway places. That's not the case. This happens in our great state of Georgia. It happened to me. I wish I could say that people who claimed to be followers of Christ did not resort to such tactics. That is not the case. This is perpetuated, sadly, by those who claim to speak on the behalf of God. I wish I could say that the stakes are not that high or the problem we're discussing is not that bad. This, ladies and gentlemen, is not the case. The stakes are the lives of children, ladies, mothers, daughters, men, sons, and others that you and I love. The stakes could not be higher. We need laws in this state like HB 1187. I'm eternally grateful that you're considering it, and any others that protect those who are victims of these heinous acts, or those trying to bring to light these types of atrocities. I implore you to pass HB 1187 and other bills like it. Thank you.
Thank you. Elizabeth Phillips. Oh, I'm sorry. Wait a minute. Hold on. I left somebody off. Vice Chair Reeves.
Thought of something as you were saying, you have custody of the minors. Mandatory reporting, that's been the law in Georgia since 2012 or earlier, right? So if somebody who had, care over a minor and they knew about sexual abuse, and instead of reporting that sexual abuse they were obligated by law to do, they had the minor and the minor's family do an NDA, that's the opposite of what the law required, right? So that would be an illegal contract in Georgia that they wouldn't be able to claim this retroactive argument under, I believe. So that's just something to look into there about mandatory reporting being the way to wipe out this retroactive argument that child molesters may make.
Okay. Okay. Any other questions? All right. Elizabeth Phillips.
She's already
Oh,
spoken.
I'm sorry. Ruth Mahorta? Hope I got that right.
Yes, you did. I know it's a hard one to say. Thank you so much, Chairman and members of the committee. My name is Ruth Malhotra, and I'm here to testify in favor of House Bill 1187. I am a lifelong Georgia resident, and I was actually one of the whistleblowers in the Ravi Zacharias abuse crisis. For nearly a decade, I served as the spokesperson for RZIM, an international Christian ministry that was headquartered here in Alpharetta, Georgia, founded by Ravi Zacharias. I believed deeply in its mission, and I also believed that the people I was working for were telling me the truth. I never imagined that I would have a front row seat to one of the biggest sexual abuse scandals in modern evangelicalism, and what I witnessed still haunts me today. In 2017, when a woman came forward with allegations of sexual and spiritual abuse, the response was not transparency or investigation, it was containment. A financial settlement paired with a draconian non-disclosure agreement that permanently silenced her. I was asked to defend that outcome publicly, even as serious questions were raised privately and dismissed. The NDA did not protect justice, it protected power. After Ravi Zacharias' death, multiple women from within and beyond the Atlanta area came forward with credible allegations of sexual abuse. An independent investigation, in which I became a key witness, confirmed a long-term pattern of abuse and misconduct. By then, it was painfully clear that the silence had not prevented harm, but rather had enabled it, as many of these women had been under restrictive NDAs. The decision to blow the whistle was clear for me, but the cost was high. My employer labeled me unsafe for going public and terminated me without severance when I refused to sign an NDA. All I wanted was to turn the lights on and push for truth and transparency. And while I've received widespread support from allies in this fight, many who are in this room, I'm still wrestling with my own complicity from years in a celebrity-driven machine that covered for the guy at the top while silencing those who sought justice. Sadly, as you heard, this story is not unique. Clergy sexual abuse is rampant and well documented across denominations, faith traditions, different institutions, impacting all age groups and ethnicities. Time and again, NDAs suppress disclosure, isolate victims, and shield organizations from scrutiny. They don't just silence individuals, they conceal patterns. They're not neutral legal tools. I know others have spoken to that. Rather, survivors are asked to trade their voices for safety, stability, or closure. That's not a fair bargain, and it's certainly not justice. Trey's law would draw a necessary and principled boundary across the use of NDAs. As we've heard, survivors of abuse should never be contractually muzzled for the price of being believed, compensated, or allowed to move forward with their lives. In closing, I'll just say that the last time I testified here at the Georgia Capitol was 20 years ago. I was a college student at Georgia Tech fighting for the free speech rights of students on our campuses. Many of you in this room were supportive of that effort. Today I come here again, this time to advocate for the free speech of victims who were told that their silence was the price of survival. This is not a partisan issue. It's about accountability, transparency, and basic human dignity, values I trust that you all champion. No matter our political affiliation, I hope we can agree that protecting vulnerable people is more important than protecting the reputations of the powerful. The truth will set us free, always, even when it's disruptive truth. I urge you to support House Bill 1187, Trey's Law, and to stand together in affirming that here in Georgia, justice requires truth, not silence. Thank you.
Thank you. Cindy Clemishire. I know I probably butchered that one.
No,
So
you did great.
Oh, okay.
Thank you. Hello, and as you said, my name is Cindy Clemishire. I am here from Oklahoma. I grew up in a small town, Hominy, Oklahoma. And at the age of 12 years old, I was groomed and abused by a predator disguised as a preacher. Robert Morris was a traveling evangelist from Texas at the time and later became the founding pastor of Gateway Church in Southlake, Texas. He and his wife and children stayed in my family's home when he would come to preach at our church, and they quickly became family friends, people that my parents and others in the community trusted. My abuse started on Christmas night, December 25th of 1982. That was the night Robert Morris made the premeditated decision to violate and defile my innocence and purity. I want to be clear with you so you understand exactly what we're talking about when we say the word abuse. This man, trusted by so many as a preacher of God's word, took advantage of a vulnerable child. I remember exactly what I was wearing, my favorite pink pajamas and bloomers with the robe snapped completely up. However, he found a way to get through that, and by Oklahoma standards, it is considered rape by instrumentation, what he did to me on Christmas night. He touched me for many years after that. It continued. The word rape often suggests brutality, but these predators are calculated. They don't just groom the child, they groom the parents and others around them to gain access. The abuse is often subtle, gentle, and not to protect the child, but to keep the child confused and quiet. The first time Robert ever assaulted me, the first thing he said to me was, "You can never tell anyone or it will ruin everything." The abuse and rape continued countless times over the next 4 years until I did finally tell at age 17. Sadly, when I told, it seemed as though Robert was right. I told the truth, and it did seem to ruin at least everything in my world. Friendships ended, marriages of mutual family friends fell apart. My relationships with others changed instantly. And at just 17 years old, I thought it was all my fault. As I began the lifelong journey of dealing with the aftermath of child sexual abuse, my life seemed to attract more shame, because shame often attracts more shame, while Robert attracted more fame. I was in and out of marriages and spent over a decade in counseling and tried to find healing through various churches and seminars. I was searching for understanding, for peace, and for forgiveness. By 2007, 20 years after the abuse ended, I contacted my attorney in hopes to recover some of my counseling expenses. My attorney, who happens to now be the Attorney General of Oklahoma, Gittner Drummond, sent a letter asking for $50,000, just enough to cover the cost of counseling. Robert's attorney responded not with compassion, but with a letter accusing me, a 12-year-old little girl, of pursuing my abuser. They countered with $25,000 as long as I would sign a non-disclosure agreement, which I refused. Had I agreed to that NDA, Robert would have continued to have power over me. Instead, I kept telling people, I kept seeking truth, and I kept healing. Because I refused to sign that NDA in 2007 at the age of 37 years old, on March 12th of 2025, my abuser was indicted by the Oklahoma grand jury on 5 counts of lewd acts with a child. Because I refused to sign that NDA on October 2nd of 2025, Robert Morris pled guilty to all 5 counts and is now sitting behind bars in the Osage County Jail. He will serve 6 months behind bars and the remaining 10-year sentence at home. Because I refused to sign that NDA, I can sit here today at 56 years old, a mom of 3 boys, and a grandmother of 3. It's really 5 because I have a couple step grandkids too. 3 step kids. And that's what happens when survivors are not silenced. NDAs may be presented as legal formalities, but in cases like mine and Trey's, they are tools that continue the abuse. They protect the abuser and keep victims in shame. They prevent children from being protected and make it harder to stop abuse from happening again. The only way we will ever have a chance at ending child sexual abuse is to tell the truth, to speak it, share it, and expose it. When NDAs are used to silence victims, we're not protecting the victims and their families. We are protecting the people destroying them. Lastly, I'm going to add a little bit to the sentence that I did say in Texas. Anyone who doesn't support Trey's law, waters it down, or prevents it from being passed, or doesn't want to find a loophole to make it retroactive, my question is, who are you trying to protect and why? Thank you.
Thank you. Holly Haynes?
She sent her written testimony.
Oh, we have it in the file?
We have someone here on her behalf.
Oh, okay.
If you would allow Dr.
I'll refer to the file for everyone. All right, and Teddy Perkins?
Good afternoon, Chair Gunter and Committee. Thank you for the opportunity to testify. My name is Trey Perkins, and I live here in Atlanta. I work as a clinical trauma therapist, and I've completed 6 additional years of graduate research on sexual violence prevention and response. There's a famous fairy tale written by Hans Christian Andersen and later developed into a classic Disney movie about a little mermaid. In this story, the villain presents the young girl with a cruel dialectic. If she wants to walk freely among people on the earth, she must give up her voice. The evil of this offer is found in the exploitation of Ariel's desire for agency, the promise of the world in exchange for the freedom to speak. I am here today as someone who has been personally and professionally impacted by the real-life analog of this fairy tale, a cruelty that is, unfortunately, not at all rare. It is a common and well-established practice for victims of sexual violence who pursue criminal recourse to be cajoled into signing NDAs, either as independent documents or as clauses in longer settlement forms. Traumatologists often reference a phenomenon called secondary victimization. In the aftermath of sexual abuse and assault, when victims have already had their agency stripped from them, the injury is further compounded by subsequent harm enacted by institutions, courts, or society. NDAs are an especially violent weapon of secondary victimization. Not only do they extend and expand the forced abnegation of agency from the primary assault, they also strip survivors of the most sacred parts of themselves, their stories. On an individual level, NDAs inhibit the possibility of connection required to facilitate healing after trauma. And on a societal level, NDAs prevent communities from accessing the data they need to recognize patterns of harm, apprehend abusers, and develop policy measures to appropriately and effectively mitigate the continuance of sexual violence. I have seen in my work NDAs used by churches, child care centers, hospitals, psychiatric hospitals, schools, and nonprofits. Some of these nonprofits, ironically, claim to be on the front lines of sexual violence prevention. It is a cudgel that enables people who have the power to protect children to shirk that responsibility, avoid accountability, and pretend ignorance at the expense of present and future victims. I am here today on behalf of those who have been silenced, some to the point of catastrophic mental injury, others to the point of death. Imagine supporting someone who has significant trauma related to trafficking or abuse, but is trapped under an NDA. Imagine watching them navigate the psychological consequences of trauma, the panic, the dissociation, the nightmares, the terror, the addiction, the self-harm. And now imagine they are not allowed to tell anyone, not their therapists, not their families, not their partners, not their siblings, not their friends, about anything that is happening in their heads. Imagine being in the victim's shoes. That loneliness is reified. It is made interminable through an NDA. I respectfully urge you to advance this law. The villainy is so apparent it is the driving force of a children's bedtime story, a Disney cartoon. No one should be pressured, coerced, or enabled to trade their stories, especially not in the name of justice. Secrets should not be allowed to die in darkness. Survivors should not be sentenced to a life in the shadows. Thank you for your consideration. I'm happy to answer any questions.
All right, I don't see any questions. Thank you. Kitty Mayo?
I have copies for everybody.
Okay.
Good morning. I recognize a few of your faces. I've worked with some of you on some other legislation regarding children, and I'm here today. My name is Kitty Mayo. I am the founder of Georgia Protective Parents. We are a nonprofit, and we are a group of concerned Georgia families who advocate and with the legislators on reform for courts and state protection for children. I am here today to stand in unwavering support of Trey's Law. Our organization represents families who have walked through the fire of the Georgia court system to protect their children from harm. We have seen where the law works, and we have definitely seen where the law does not. Today we are discussing one of the most dangerous failures, and that is non-disclosure agreements. In the dark corners of our legal system, these gag orders, if you will, have been repurposed as a tool to buy the silence of adults who were abused as children or even witnessed this deviance. Today we are asking you, is an institution's reputation worth more than a person's life? My stance on this isn't just based on my work as an advocate, it is also rooted in my background. I am a pastor's daughter and a former children's pastor. I have spent years working with church staffs and seen the inner workings of the organizations that are built and promise to be safe havens. I have seen the bad side of silence, and I have seen what happens when an organization is driven by misguided sense of protecting the mission instead of protecting their flock. They have to choose a settlement check to ensure a victim never speaks again. When we silence a survivor, we don't just protect the abuser, we empower them. We allow them to move from church to church, from organization to organization, from community center to the next, when there is no public record of their wreckage that they have left behind. In my experience, this is a slow burning trauma that destroys the survivor while the institution pretends the problem has been solved. An NDA tells a survivor that their pain is a liability and their voice is a threat. Tragically, Trey died. He is no longer here. He's no longer here to advocate for himself, but we will. But his story is a haunting reminder that while an NDA may protect a balance sheet or a company's image, it can break a human soul. We cannot continue to allow our legal system to facilitate the spiritual and emotional execution of survivors. As a founder of Georgia Protective Parents, we are taking a stand because we know the cycle that abuse thrives in the dark. When a predator or negligent organization knows that they can settle their way out of public accountability, the incentive to change never arrives. Opponents of this bill may argue that NDAs provide closure for family, but as someone who works with protective parents every day, I assure you there is no closure with gag orders or NDAs. True healing requires the freedom to speak, to warn others, and to ensure that your nightmare isn't repeated to the family next door. Georgia has the opportunity to lead. I was raised as a pastor's daughter to believe that the truth sets you free, but our current law allows the truth to be purchased and locked away in a drawer. By passing Trey's Law, you are declaring that in the state of Georgia, a child's safety is not negotiable, and it's not a commodity. You are telling survivors that their voices are more valued than an institution's PR strategy. Let's stop protecting the bad actors and start protecting the children. Let's pass Trey's law and finally give truth the light it deserves. Thank you.
Okay. All right. Thank you, ma'am. All right. That's all the folks I have on the list. Is there anybody that might have missed getting on the list? Back here. You want to come up? Okay. Just tell us your name and what you want us to know.
Okay, it'll be really quick because everybody else has already given a broad and very detailed account to what's going on. My name is Dr. Margie Gill, and I am the chair of Work Group 7, Work Group 9, the Human Trafficking Task Force here in the state of Georgia. I sit on 2 committees because this is my passion. I strongly believe that this law that this bill that we're talking about today, it really needs to be passed because I work with survivors day in and day out of all ages, all genders, all races throughout the state of Georgia. The organization that I represent is Tabitha's House. We are one of the leading organizations here in the state of Georgia. We work with Jeff Shaw. We work with Wellsprings Living. We are one of the main contact locations for the state. As it relates to the biological functions, there is empirically validated research that shows what trauma does to the brain. When I am not in the role of executive director and founder of Tabitha's House, I work at Brunel University as a full psychology professor. And so in that role, I'm teaching other grad students and other clinicians how to work with people who have been exposed to trauma, and so that they fully understand how the brain changes when trauma presents. When that trauma presents, even if it's at 5 years old, the brain halts development. And that person has to go through extensive treatment in order to, I can't say that they will ever, their chronological age will ever match their developmental age. They learn how to function. And so I just wanted to just shed more insight and more light on the impact of trauma, the role of, just having the support of the committee to advance the bill that's presented before you today. Do you have any questions?
I don't see any. Thank you very much.
Thank you.
Anybody else, just to make sure? All right. Ms. Hong, anything else you want to tell us?
I just want to thank everyone for coming and having the courage to share their stories. And I ask this committee to pass HB 1187.
Okay. As is or with amendments?
I'd be happy to entertain any amendments if committee members have any language, but we will be working on the retroactive, as Representative Evans mentioned, and if there's any other suggestions or amendments, I'd be happy to.
All right. Vice Chair Reeves.
Motion at the appropriate time.
Let's go ahead and make that motion.
Move to pass.
Second.
All right, I got a motion and a second. Any further discussion? Representative Evans.
Thank you, Mr. Chairman. While we were here, I was able to go back and look at the Texas law, and I compared Texas's constitution to our constitution to the U.S. Constitution. Essentially, the contracts clause in all 3 of those is the same. And it looks like the Texas language, the way they got around it was there is a public policy exception to the contracts clause. And I think combine a statement about these provisions being against public policy, it being very tight and excluding or allowing the continuation of the ability to keep like the amount secret. It's just the sexual abuse and acts relating to the sexual abuse. It's very specific. And then it also had language that said that you could only enforce a prior agreement that kept you from talking about these things if you had a declaratory judgment from a court. So I think that's sort of a 2-pronged way to protect it. I just sent that language Brock, to you and also to Miss Little outside, if somebody could print that, they could pass it around. I think it would work. I think this committee could probably wordsmith whatever was left over, but to me, the language, and I wish we'll hopefully have it in front of us in a minute, would do right by victims, but also keep us true to the rule of law, but show us to be what we are, which I think is people of goodwill who want to try. And I believe we would be being allegiant to both of our duties here if we were to pass something like this. So that language will hopefully come around. And it's a little bit of discussion too. I wanted to ask the chairman, I don't know if the question would be appropriate to you, Chairman, or Vice Chairman, or Representative Hong. But I know the last time we really talked about bills that got to childhood sexual assault, we had a lot of folks come in here and testify for protective measures, just like we had today, which is really hard to do. And this committee listened, which is our duty and our obligation. But there was all of this, there were a lot of folks outside that were opposed to what we were trying to do. And they testified in the dark. They sent their objection in the dark. And I was wondering if the chairman or Representative Hong could share if they have been approached in the negative on this, and those folks were just not strong, or just not willing to let their faces be shown here today, and said that they were against something like this for the good of the committee to know.
I have not heard from anyone opposing this legislation.
I don't recall that either.
Excellent.
And I have not, and I've got confidence in Vice Chair Hong and the governor's office to get a legally enforceable retroactive application, because I think it's an illegal contract under 1381 for somebody to get an NDA for childhood sexual abuse. I think it's illegal.
I will say, as the language is coming around, I do think you'll need to add back in, Texas had a different way of defining sexual abuse, and I think we were referring to code sections that would need to be added into this language. But this, I think, are the applicable parts of the Texas law that I think would allow us to do what it feels like is the will of the committee to do here.
Okay.
And this would probably be inserted, line 16 through 22, I think would be how this would work if you also add in the definition of sexual abuse.
Representative Holcomb.
Thank you, Mr. Chairman. I wanted to just personally thank everybody that testified. It was very, very helpful. And so thank you for your courage in coming forward. I have very little personal experience with child abuse, but I have a significant amount of experience with sexual abuse of adults by many interactions with both advocates and survivors. And the neurobiology of trauma is real, and it's significant, and it's long-lasting. And there is a real societal impact on the relationships that the victims then have later in life. And it strikes me that one of the other benefits to this legislation, besides what has been expressed in terms of prohibiting and preventing additional harm because of the confidentiality treatment, is, while likely somewhat minor, but still minor matters because it can impact individual lives, would be this could potentially operate as a disincentive for people to know that this isn't going to be something that's hidden just because you can afford to write a check. And I also support what Representative Evans is trying to do. Thank you.
All right.
I have a copy. Oh, sorry.
Probably we need to add the word childhood too.
Everywhere sexual abuse appears, childhood is one of them.
All right, I think at this time, do I hear any motions for amending the bill? Representative Evans.
Thank you, Mr. Chairman. I would move, or if the representative would accept it as a friendly amendment, to substitute lines 16 through 22 with the language that's been circulated, with a couple of additions to the printed language, which would be that the term sexual abuse would be substituted for childhood sexual abuse, and that the first instance of that term would say as defined in code section, and then Representative Hong would fill in those two code sections. But that would be the either amendment to move or an amendment to proffer as a friendly amendment.
Chairman, given that this is the first time I'm looking at the language, we can go ahead and make any changes in a sub, but I would like to pass it as is at this time. In response to her, Representative Evans asking if it's a friendly amendment. Certainly, we're going to look at it. It is not that we oppose it. We just want to go through the language and make sure.
Well, I'll move it if it won't be accepted as friendly.
So do you want this passed today, or you want me to table or hold it until next meeting?
I'll leave that up to you, Chairman. If we do, I know there's a move to pass, and we would like to have it passed as is. If we can move forward, so that we can work on a sub, or if the chairman wishes, we can go ahead and come back. I would like to see this passed, given the fact that we have many who are here, and I would not want them to be coming back for another committee hearing, because I know several have traveled a lot to be here. And certainly I'll be in contact with them as far as if there's any subs. And again, it's not that I oppose the language, it is just that I want to make sure that we're looking at it, and we're looking at, I want to make sure that we're able to do this and do some research.
Okay.
I'll move it. If it's the will of the committee to vote down the amendment, that's fine. And I just want us to do the best we can. This is a committee of learned attorneys. The state of Texas had the courage to do a bill that included the language that I've passed around as an amendment. I've explained why I think it would pass constitutional muster, and why it would be about the best thing I could think that this committee could do to make sure that we are protecting the most victims of childhood sexual assault as possible.
If we pass it out of here, the next opportunity we have to amend it would be in rules, I think. So, which is not easy. Yeah, that's not easy. So that's why I'm trying to figure out, either we take a recess today and look it over and see if we can't come to a conclusion, and then come back in here and vote it in or vote it out, whichever way you see it, and then have a final vote to get it to rules. But that we're going to need to break, and it's going to take a little while for us to figure that out. So,
well, I'll move it,
Chairman.
I'll move it, and we'll see. I mean, the committee will do what they do.
okay. So, all right. Okay, we have a motion and a second on the amendment. Has everybody had a chance to look at it? Any questions or discussion about it before we vote? All right, hearing none. All those in favor of the amendment, say aye.
Aye.
Any opposed? Okay, the amendment's in.
We need to do the bill as amended.
All right, is there any further discussion, any other amendments to the bill? Hearing none, all those in favor of the bill say aye. As amended. Any opposed? All right, bill's passed.
Thank you, committee. Thank you, Chairman.